Good morning, and thank you for joining us for this morning's webinar on your college-age child is an adult. Now what? I'm Jenna Ritter Tomasic, Marketing Coordinator of Events for Ward & Smith, and I'm on the call today to moderate questions for Virginia Carter, a trusted state's attorney in our Wilmington office. Before we begin, please note that we are going to utilize a few PowerPoint slides during this webinar, and we think it will be helpful for you to be able to see both the video feed and the slides at the same time. To do this, you may need to make one adjustment to your view settings. Find the View Options button on the top or bottom of your screen and click on it to see your options. Then choose the side-by-side mode. The slide deck should appear on the left and the video feed should appear on the right. You can then slide the separator to the left or right to adjust the size of each view. If you have any issues, please reach out to us via the Zoom chat feature and we'll try to troubleshoot for you. Now, I'll turn the mic over to Virginia so we can begin.
Thanks, Jen, and thanks for joining today. Today, I'm going to talk about the impact of your child turning 18 years old, because it's not something that you may have realized, but your child upon reaching 18 is viewed differently under the law. In North Carolina, your 18-year-old has reached the age of majority. They can vote, they can enlist, they can do all sorts of things, but the impact on you as a parent is that you may not be able to make the same decisions for your child that you could when they were a minor. So there are some basic documents that you'll need to think about and encourage your child to implement. So today I'm going to talk about those basics, why they're important, and then go over some other considerations that you may want to think about because your child is now 18, that may have impacts on your planning. And there are also some liability asset protection steps that you may want to take if your child is off in college and those sorts of things. So let's dive in.
Great, thanks, Virginia. So our first question today is, what are the 5 basic estate planning documents that every parent should consider providing to their college-age child?
So there are 5 essential documents that every adult should have. I'm going to list them in the order of importance for an 18-year-old. The most important document for an 18-year-old is to have a healthcare power of attorney and a HIPAA authorization. Those are the documents that name somebody to make a medical decision for them in the event your child were to be in an accident or become incapacitated. The HIPAA authorization, HIPAA is the Health Information Privacy Law. And a HIPAA authorization, if your child has signed one, would give you as the parent the right to discuss their medical condition with their doctor. The other documents are a durable power of attorney, which is a financial power of attorney. In that document, your child names somebody to handle their finances, any sort of monetary, bill paying, any sort of financial decisions that need to be made for your child while they are unable to make them. A durable power of attorney would name somebody as their agent. And then finally, probably less important for an 18-year-old, but a will and a living will are the last 2 of the basic documents that every adult really should have. A will is going to direct the disposition of assets of their estate at a child's death. Again, unlikely to happen. Also, children don't have a whole lot of assets, but it's a good thing to have in place. And then also a living will, which is the document that states end-of-life decisions. If you're beyond all medical hope, what would you want to happen? So those are kind of the core estate planning documents, not just for 18-year-olds, for any adult, but those are the basics that will give you the ability to take action for your child if it became necessary.
Great. So what are some of the consequences of not having a healthcare power of attorney or HIPAA authorization in place should your child become ill, injured, or hospitalized?
So you hear the horror stories. If your child is 18 years old or older and were to be in an accident and in the hospital, you as the parent cannot get the child's medical information. You have no legal right to discuss your child's condition with their doctor. Even if your child is still on your health insurance, even if you're paying all the child's bills. Now, a doctor could choose to disclose health information if the doctor deemed it, to be in the best interest of the child, but you may need to go to court, for example, to get approval to take action that you think is in the best interest of your child. So it's just not a situation that you want to find yourself in, your child being in trouble and you not being able to kind of understand what's going on, being in the dark. That can all be avoided by just having your child sign a healthcare power of attorney and a HIPAA authorization that would name you. So if you, before your child reaches 18, these documents are not necessary because the child, under the law, you make all decisions for the child. It's that 18th birthday that is crucial, and when under the eyes of the law, the child becomes a grown-up. We recommend kind of having your child sign these documents, also keeping them somewhere, like, for example, you can keep them in a PDF, in an email, so that you have them, able to access them quickly if you needed to in the event of an emergency.
Thank you, Virginia. So the next question is, do you have any guidance on how to discuss these documents with a son or daughter who recently turned 18? What if they are resistant to having such documents or make designations that you don't agree with?
Yeah, so that's a good question. I know when I turned 18, my dad is a lawyer and he had these documents prepared and said, you need to sign these. If anything ever happened, we need to be able to act for you, sign these documents. And I did. So, I feel like if you just explain the reason for the documents, that they're not to control your child, they're just for the purpose of if there was an emergency. These are really crucial documents that are going to allow the parents to be there for the child. If your child doesn't want to sign them, though, you can't force your child to sign them. One of the requirements for legal documents is that you can't force somebody to sign documents. They would not be valid. So if they won't sign it, then there's not much that you can do. But I think if you explain to your child or have an attorney explain to your child that the reason for having these documents is for these emergency situations, then hopefully they will understand. And again, at a minimum, that healthcare power of attorney and the HIPAA authorization, which are really only going to be applicable where the child is unable to communicate with their own doctor and make their own medical decisions. Those are really the crucial ones. And I would think that a child could understand the reason, and I think there's little risk in signing those documents.
So our next question is, if an adult child creates these documents now, when should they be updated? After graduation, once they get married, after their own children are Lauren?
Yeah, so these documents, once they're signed, they're not going to expire unless the child does something to change them. So like any adult who signs estate planning documents, if they have a significant change in circumstances, then it's a good idea at that point to sign new estate planning documents. We tell people generally every 3 to 5 years, pull out your estate planning documents, look at who you've got in all the roles, what they say, because you may want to update them. So certainly if the child were to get married, it may be appropriate at that point to execute new estate planning documents. And also definitely if your child has children of their own, they should execute estate planning documents. And, you know, they're just over time, it may, you know, they may have other people that they would want to name in the roles other than parents.
Moving on, my child has money in a UTMA account set up by grandparents. Does turning age 18 mean my child will now control those assets?
So we have a good number of clients who will set up these sort of UTMA or custodial accounts for minors. And the custodial account is just a way to, a minor can't own assets. So the custodial account is an account in the name of the minor, but it's controlled by the custodian. It's also called a UTMA account. And under North Carolina law, turning 18 does not mean that the child controls the assets. The age for a UTMA account is actually 21. So if your child has these sorts of accounts set up by a grandparent or a parent, then it would be at 21 that the child would become the sole owner and in control of those assets. Now, in certain circumstances, those accounts might be pretty large, and it may be the case that you were not comfortable with your child having control over a significant amount of assets. And in that case, there are steps that we can take. The child has to be a part of that. But just one example is if you have a UTMA account or other assets that are going to be held in a young adult child's name, you could have the child set up a revocable trust. And that's a good tool for this circumstance because the revocable trust kind of bifurcates the beneficial interest from the control of the assets. So your child would set up the trust and would be the beneficiary of the trust, but could have the parent as trustee kind of managing the assets for the child, or the parent and the child together involved in management decisions for those assets. And again, that's for larger values where it makes sense. Just something to keep in mind.
How might my child's reaching legal age impact my own estate planning?
So really there, your child is 18 or older. That means that your child can serve now in various roles under your estate planning documents. So if you wanted to, if it was appropriate, you could now implement your own will and powers of attorney that name your child to act for you if you were comfortable with that. So something to keep in mind, again, it may not be appropriate yet, but upon reaching 18, your child could be the executor, your child could be a trustee, and your child could be an agent for you under a healthcare or a durable power of attorney. In addition, when your child goes to college, you probably have a better sense of your child's ability to manage finances and whether they're responsible and those sorts of things. So it could be a good time to revisit your own estate planning for that reason as well, and look at how you're providing for your child. So are you comfortable, based on how your child is, are you comfortable with that child receiving assets outright potentially? Or would you want your child to not receive assets outright and to have somebody else controlling them because they might not be responsible yet? So anytime that, again, you have a major change in circumstances, which a child going to college is pretty big, it's a good time for you to get your own estate planning documents back out and just look at what they say.
What steps should I consider to protect myself from potential liability of my child who is in college?
Yeah, I mean, college kids are all super responsible, right?
Really?
So there are a couple of kind of basic thoughts here. As a lawyer, we're always worried about liability and taking the steps that we can to protect from potential liability from being sued. So the biggest one that comes to mind is if your child is driving a car, make sure that car is in your child's name. Once your child reaches 18 years old, 18 years of age, they can own the car, and it is a good idea to put that car into their name. Otherwise, if your child were to be in an accident in a car that is owned by you, you will be potentially liable if they were to injure somebody in the accident. You could be sued. So best practice is if a child is driving a vehicle, that vehicle should be in the child's name. Another good rule of thumb is a good umbrella liability, general liability insurance policy. So usually under these policies, a child who is a full-time student would be covered as well. So that could be another source of protection if your child were to get into trouble. This would be an umbrella policy that you have could benefit your child. Again, check with your policy terms, but that is a potential source of protection. In addition, if you have a child who is in college and living in an off-campus house, you may want to consider adding that child's residence as an additional insured location under your homeowner's policy. Again, policies may vary, but generally a full-time student is covered under the parent's policy. So adding that child's residence as an insured location gives, just another layer of protection were something to happen with your child. And then just being smart. If your child is home from school and people are over at your house drinking and then get into an accident, again, you could be liable if they're underage, if they're getting the alcohol from you. So that's why those umbrella insurance policies are really crucial. Also, just kind of some other thoughts, keeping a child's credit card limits low. If you've helped your child to get a credit card, just keep those limits low so that they can't go out and rack up a whole lot of debt. If your child is out of college, talk to your child about the importance of having renter's insurance in place because of all these reasons. The renter's insurance is going to protect their belongings and then also will give them a little bit of liability protection as well. So just kind of being aware these sorts of steps that you can take, I think are important. Insurance is always the first line of defense there, and is a good one.
Thanks, Virginia. So that concludes the portion of the discussion of the questions that we thought should be addressed in today's webinar. We do welcome questions from our participants. I'll open the floor for just a moment, and I'll wait for a few moments because I know it takes some time to type. If you do have a question, please type it in the Q&A box, and Virginia will be happy to answer it. Okay, I don't see any questions coming in, so thank you so much, Virginia, for those in attendance. Following today's webinar, you will be sent an email with a list of articles related to the issues that Virginia discussed today and information about Wardensmith's Essentials Package, which is a product that helps bundle those top 5 estate planning documents that Virginia mentioned at the beginning of our discussion, as well as a link to sign up for our Trust and Estates client alerts. In addition, we do have a recording of today's webinar, and we'll send that along too if you'd like to share it with anyone. We so appreciate you taking your time to join us today, and that concludes the webinar. Thank you.
Thanks.